Hi everyone. Today's unit that we'll be doing is criminal law, and we'll be doing learning outcome 5, which is to understand the nature and application of defences. I'll just give you a summary of what we did in the last session. We did learning outcome 4, which was to understand the general principles of incoherent offences. We looked at the types of incoherent offences. We also looked at the meaning of assisting or encouraging crime, and we distinguish between intention to commit crime from an attempt. So we looked at the different types of incoherent offences, and these offences where the main crime has not been committed. So this is where they are concerned with planning and preparing for an offence. We looked at the features of incoherent offences, which was preliminary, freestanding and harmless wrongs. We then went on to look at the attempt in regards to coherent offences under section 1 subsection 1 of the Criminal Attempts Act 1981. We looked at the actus reus of attempt and the mens res of attempt with reference to leading cases such as Anderton and Ryan 1985 and R and Shivapuri 1987. We then went on to look at the various tests for attempt act, which was substantial steps, the proximity element. We looked at the probable desistance and res ipsa locere. We then went on to look at the issue in regards to conspiracy, the law around conspiracy under common law. We looked at the actus reus of conspiracy and the mens res of conspiracy with reference to cases in regards to conspiracy and intention. We looked at assisting. We also looked at assisting under common law. We looked at the Serious Crime Act 2007 under section 44 and up to 46. And then we looked at the meaning of assisting and encouraging crime in regards to accomplice liability. We looked at the issue of quite an important leading case, in regards to accomplice liability was the case of R and Jogi and Ruddock in regards to accomplice. And we went on to identify the elements of intent, so the defendant's elements and defences, and we looked at intention as well. And this week, this session, we'll be looking at understanding the nature and application of defences. So we will be covering in learning outcome 5 is the examining the specific and general defences. We'll be looking at illustrating the defence of insanity, duress, mistake and involuntary intoxication, and to illustrate the application of self-defence rule. So 5.1, we'll look at examining the specific and general defences. So the categorization of defences. So defence type under common law, you've got it's created by a court, and statutory, it's created by a statute, federal legislature. Denial or failure of proof creates doubt in one or more elements of these offences and prevents the prosecution from meeting its burden of proof. Affirmative, which the characteristic is raises an issue separate from the elements of offence. The defence type is imperfect and it reduces the severity of the offence. The defence type perfect results in an acquittal. The defence type factual is based on the issue of fact. The defence type legal is based on the issue of law. Defence type alibi, which asserts the defendant as somewhere else when the crime was committed. The defence expiration of the statute of limitation asserts that it's too late for the government to prosecute the defendant for the crime. And the defence type justification, which claims that the criminal conduct is justified under the circumstances. And then the final defence type is excuse, claims that the defendant should be excused for his or her conduct. When a person is accused of a crime, the onus is on the prosecution to prove that the individual actually committed the crime with the intent. So general defences can be mounted by the defence team to combat the prosecution's contention that the accused individual had the intent. Criminal burden of proof. So we've got the criminal burden of proof, and then we've got the prosecution in this diagram, which identifies the elements of defendant committed the crime, either they disapproved the defense or they committed the crime, and then if they committed the crime, it was beyond reasonable doubt, or disapproved that beyond a reasonable doubt there was some jurisdiction. And then for the defense, you've got affirmative defense, preponderance of evidence, so some justification. And then it goes on to preponderance of evidence and some justification, burden of production only, and then prosecution must disapprove the defense. A party's duty to produce sufficient evidence to support an allegation of or an argument. Plaintiffs in civil cases typically have the burden of proving their allegations by a preponderance of the evidence, as we've just mentioned from the diagram. In criminal cases, the prosecution typically has the burden of proving its allegations beyond a reasonable doubt. And again, that is in that diagram, what we've just explained. Criminal defenses. So you've got the defense of insanity. The defense of insanity is a general defense which is available to all crimes. Where a defendant is found to be insane, the juries are directed to give a special verdict of not guilty by reason of insanity under Section 2 of the Trial of Lunatics Act 1883. The mental defense concedes that the crime was committed by the defendant, but endeavours to mitigate the ramifications of the event by proving that the individual actually lacked intent. Insanity is frequently defined as a lack of understanding of the illegality of a criminal act or an inability to conform the law. In order for a defense of insanity to be mounted successfully, one must be able to prove that at the time of the act was carried out, the accused was affected by a disease of the mind that prevented the person from knowing the nature or impact of the crime they were committing. Alternatively, it could be used to argue that the individual, while aware of their actions, could not tell because of their illness that the act was criminal. Where a person wishes to raise an insanity defense, it is the responsibility of the defendant to prove their insanity. The next defense is mistake. Where the defendant acts under a mistaken belief of the circumstances, they may be afforded the defense of mistake. Where a defendant acts under such a mistake, the mistake prevents them forming the mens rea of the crime, and thus mistake is not really a defence as such, but relates to the absence of the elements of establishing liability. Mens rea in Latin is the intention of knowledge. The general defence of mistake may be mounted to disprove the notion that an individual intentionally committed a crime. For the defence to be successful, as we mentioned, it has to be proven beyond reasonable doubt that the accused's belief was honestly and genuinely mistaken. The next defense is self-defense. Where there is evidence of self-defense, this must be left to the jury. The burden of proof lies on the prosecution to establish that the level of force was unlawful, that is excessive in the circumstances. A self-defense can be mounted in cases where you were being threatened, another person was being threatened, or where property was being threatened. A clear example is using reasonable force against intruders. With self-defense, a person does not have to wait to be physically struck before acting in self-defense. Each self-defense case is unique, and whether the defense can be deemed reasonable depends on the facts and circumstances of the case in question. For example, a person who was punched in the face could not take a gun, shoot someone dead, and successfully posit a self-defense case. Rather, they would be convicted, since lethal force can only be used by an individual when they reasonably and truly believe that they or another person is about to seriously injured or even killed. The extent of crime, for example, murder, would not be considered proportionate to the first crime or appropriate. Intoxication. So this is where a person is intoxicated through drink or drugs and commits a crime. The level of intoxication may be such as to prevent the defendant forming the necessary mens rea of the crime. Public policy plays a strong factor in ascertaining whether the defendant's intoxication may be used as a defendant to negate the mens rea of crime. Crimes committed during intoxication occur frequently, and this defence in some cases can be mounted to prove that the individual charged did not have the mental capacity necessary in order to carry out the crime or understand the implications of it. The defence is more successful in cases of involuntary intoxication, where the accused become involuntarily intoxicated, perhaps as a result of having their drink spiked. In cases of voluntary intoxication, it may also be possible to argue that the individual, because of their intoxication, did not have the capacity required to commit an offence and can therefore be used to secure an acquittal. Voluntary intoxication cannot be used as a defence in the cases where the individual has committed the crime. It is sometimes difficult to prove beyond reasonable doubt that an intoxicated person is able to exercise control over their actions despite lacking an understanding of what they are doing. When intoxication is used as a defence, it is perceived as a denial of intent and is usually used to indicate that the defendant has committed the crime but did not know, because of their intoxication, that the criminal ramifications of the behaviour would be criminal. The next defence is duress. So there exist two defences of duress: duress by threats and duress of circumstances. The rationale behind the defence of duress is that whilst the defendant clearly has the mens rea of the crime, in committing the crime, they are acting out of the compulsion and are therefore not exercising freedom of choice. The defence can be mounted in cases where the individual believed that they were truly at risk of harm from a third person if they failed to carry out the act. The evidence for duress must be raised by the defendant, with the prosecution inheriting the burden of disapproving the assertion. A defence of necessity, the next one. The defence of necessity in criminal cases. Criminal law is where the defendant is arguing that it was necessary for them to commit a crime. The defence of necessity often operates where the defendant has two alternatives: either to commit a crime or suffer or cause another extreme hardship. A defence for necessity, as we stated, mounted in instances where a crime had to be committed in order to save people from harm or prevent more serious crime. For example, trespassing on someone's property to prevent someone from drowning could be seen as necessary crime. The crime of trespassing is less severe than the consequence of allowing someone to drown, which would be death. The defence of necessity can also be used in cases where an individual caused harm to another person whilst assisting in the lawful arrest of an offender. And when the courts actually in necessity consider this defence, the courts assess and evaluate the reasonableness of the defendant's actions in relation to the circumstances of the crime. They will consider principally whether the response was proportionate to the threat being levied. (5.2) Illustrate the defence of insanity, duress, mistake, and involuntary intoxication. Defence of insanity. The defence of insanity is a general defence which is available to all crimes. Where a defendant is found to be insane, the jury are directed to give a special verdict of not guilty by reason of insanity under Section 2 of the Trial of the Lunatics Act 1883, which I mentioned earlier as well. Mandatory detention still applies where the penalty for the offence is fixed by law, for example, murder. In all other cases, detention is at the discretion of the judge under Section 5 of the Criminal Procedure Insanity Act 1964. Insanity is relevant at 3 points: insanity before trial, unfitness to plead, and insanity at the time of the offence. Insanity before trial. Where the offender is in custody but is obviously insane, the Home Secretary has the power to detain him immediately in a mental hospital. Confirmation from two doctors of the offender's state of mind is required. Unfitness to plead. The question of unfitness to plead may be raised by the defence, prosecution, or the judge. A special jury is empanelled to decide if the defendant is unfit to plead under Section 4 of the Criminal Procedure Insanity Act 1964. The jury can make a finding of unfitness to plead if, on the balance of probabilities, any of the 6 things that was beyond the appellant's capabilities. Firstly, understanding the charges. Secondly, deciding whether to plead guilty or not. Thirdly, exercising his right to challenge jurors. Fourthly, instructing solicitors and counsel. Fifth, following the course of the proceedings. And sixth, giving evidence in his own defence. Unfitness to plead, and the leading case examples are the case of R.M. Pritchard and M. John 2003. So R.M. Pritchard is quite an important case, leading case for the case of insanity in regards to it. Case that we will go through is the case of R.M. John 2003. In this case, the appellant was convicted of various charges of a sexual nature for offences committed against his partner's granddaughter when she was aged between 8 and 10. The issue of the appellant's fitness to plead was raised by the defence, and a jury was empanelled to try that issue. Medical evidence was the appellant suffered a serious impairment of his short-term memory caused by long-term effects of excess alcohol, but that he was otherwise capable of understanding the charges against him. The jury found that he was fit to plead his case, proceeded to trial, where he was found guilty of the charges. He appealed against the jury's finding of fitness to plead on the grounds that the trial judge had set the threshold for fitness too low. It was held that the appeal was dismissed. The Court of Appeal approved the trial judge's direction that the jury could find unfitness to plead if the defence could establish on a balance of probabilities any of the 6 things that were beyond the appellant's capability, as we mentioned earlier. On the evidence, it was open for the jury to find that he was fit to plead, and the question is always one for the jury, even if the medical evidence supports a finding of unfitness. If the defendant is found to be unfit to plead, a second jury is empanelled to establish if the defendant has committed the actus reus of the crime under Section 4A of the Criminal Procedure Insanity Act 1964. If the jury is of the opinion that the defendant did not commit the actus reus, the defendant is acquitted, and that is the end of the matter. If, however, the jury have the opinion that the actus reus was committed by the defendant, the judge may make an order under Section 5 of the Criminal Procedure Insanity Act 1964. Insanity at the time of the offence. The question of insanity at the time of the offence is determined by the application of the McNaughton rules. And the case of McNaughton rules in 1843, under the McNaughton rules, it must be established that at the time of the offence, the defendant was suffering from a defect of reason, which the leading case for this is R and Clark. In this case, the defendant was apprehended for shoplifting after she placed certain items, including a jar of coffee, a jar of mincemeat and butter, into a handbag. She was charged with theft, contrary to Theft Act 1968, Section 1, and was convicted. The defendant asserted that she had no recollection of doing so, and that she must have done so in a bout of absent-mindedness, and hence that she has no mens rea for the offence. Medical evidence was adduced to show that she was diabetic, and in addition, both the GP and the psychiatrist testified that she was suffering from depression, which was associated or could be associated with such bouts of absent-mindedness. The trial judge ruled the appropriate defence was one of insanity. The court held that, in this case, that the defendant had not articulated an insanity defence, rather was merely seeking to deny mens rea, and that in any event, a case of temporary absent-mindedness is very far removed from the standard necessary to succeed in an insanity defence. In order for a defence of insanity to succeed, the defect of reason of the defendant was substantial. Further, the defendant in this case had simply lapsed in her ability to use her power to reason, whereas insanity is relating to a more long-term lack of ability to use one's reasoning. One of the other elements to establish was the defect of reason must be caused by a disease of the mind. And this was the R and Kemp case, 1957. In this case, the defendant assaulted his wife with a hammer. He had no previous history of violence and no apparent motive. He was charged with causing previously bodily harm, contrary to the Offences Against the Person Act 1861. The defendant argued that the attack was a result of loss of consciousness linked to arteriolysis, with the hardening of the arteries causing congestion of the blood in his brain. This was used by the defence as the grounds for a defence of automism. The trial judge, however, directed the jury that the appropriate defence was one of insanity, and the court held that hardening of the arteries could amount to a disease of the mind due to its effect on the person's reasoning ability. Essentially, the court was not concerned with how a defendant got to a certain state of the mind, but that he reached that state was in it at the time of the committing the offence. The term disease of the mind was designed inter alia to limit the effect of the term defect of reason, so as not to permit stupidity or to act as a defence. The trial judge had therefore been correct in directing the jury that the appropriate defence is insanity and not automatism. The next element that was established was that the defect of reason must be such that the defendant did not know what he was doing, or if he did know, he did not know the act was wrong. And the leading case for that is the case of R and Cordia, 1916. In this case, C appealed against his conviction for murder at trial. Expert witnesses had disagreed on whether he could be certified as insane, and the court in this considered the meaning of the words nature and quality in the McNaughton rules, and held that the court in that case did not intend to distinguish between the physical and moral aspects of the act. If C understood the physical nature of the act, it then ought to be considered whether he knew it was wrong. If he was aware that the act was wrong in law, then he could be considered aware that he ought not to do it. On the available evidence, the court held that whilst it was clear that C was abnormal mentally, there was sufficient evidence that he was conscious that the act was wrong and contrary to the law, and the appeal was accordingly dismissed. Defence of duress. There are two defences of duress: duress by threats and duress of circumstances. Duress of circumstances is the most recent development in criminal law and is closely linked to duress by threats and the defence of necessity. Duress by threat and duress of circumstances are largely governed by the same criteria. Thus, many of the cases are authority for either type of duress. The rationale behind the defence of duress is that whilst the defendant clearly has the mens rea of the crime in committing the crime, they are acting out of compulsion and are therefore not exercising freedom of choice. Duress by threat. This identified as threats of immediate death or serious personal violence so great as to overbear the ordinary powers of human resistance. It is for the jury to decide whether the threat was sufficiently serious to warrant the defence of duress, which will be balanced against the seriousness of the offence, as in the leading case of R and Hassan 2005. In this case, Hassan was charged with the crime of aggravated burglary. He was associated with a gang and relied on the defence of duress, pleading that he was blackmailed into committing the burglary to prevent his family from being harmed. The court held in this case that the defence of duress was unavailable for Hassan because of his voluntary gang association, and as such he should have foreseen or ought to have foreseen the risk of being subjected to compulsion to commit criminal offences. While he may not have foreseen that he would be compelled to commit a burglary, his association with the gang and other persons with a tendency to commit unlawful acts was enough to exclude the defence. Further, the court found that his confession was initially intended to be neutral on the face of it. However, its contents became damaging at trial when it was clear that he was inconsistent with the defence of duress Hassan was relying on. Therefore, it was admissible evidence under Section 76, Section 1, that the appeal was allowed and the conviction was upheld. The elements of the defence of duress by threat and the specified crime, as in the leading case of R and Co. 1994, and the threat of immediate serious or serious harm, as in the case of R and Hudson and Taylor 1971. Defence of duress, defence by threat, elements of defence of duress by threat, threat of death or serious injury, and that was the case of Valderrama Vega, 1985. In this case, Valderrama Vega was a retired police officer who arrived at Gatwick Airport from Colombia when he was stopped by customs officers. They searched his suitcase and found almost 2 kilograms of cocaine hidden in a concealed compartment in his luggage. He was interviewed at length and provided 2 defences. The first was that he did not know that he had cocaine in the suitcase. Rather contradictory, his second defence was that he bought the cocaine in under duress. Specifically, the basis of duress was that he alleged that he had received calls threatening his and his family's lives from a mafia type of organisation. He argued that he was also under severe financial pressure and that he had been threatened by the disclosure of his homosexuality. The decision in this case was that the appeal against conviction was dismissed. It was held by the court that the jury was permitted to consider the cumulative threats in this case. However, if the threats of death or serious injury were not part of this, other such reasons could not be employed as sufficient defence. Persons for whom the defendant was responsible, as in the case of R and Schuyler 2001. I'm going through some of the cases so it gives you an idea of the elements of duress, but you could look at the rest in your own time as well. The next one is the threat must be so great as to overbear the ordinary powers of human resistance, as in the case of R and Graham, 1982. And in this case, Paul Graham had been drinking and taking drugs when he and his homosexual partner killed Graham's wife. Graham claimed he was under duress as his co-defendant was a violent man. He was charged with first-degree murder. He pleaded against the conviction on the basis that the trial judge applied a subjective test to the defence of duress. The decision and the outcome in the case was that the trial judge was correct in putting to the jury a subjective test and then objective tests to determine if the defence of duress could be relied on by Graham. The court further held that while there was no binding authority that determined whether the test of duress should be purely subjective or objective, it was essential to limit the defence of duress by means of an objective test, the objective test being the reasonable man principle. The court defined the test as whether Graham was impelled to act as he did as a result of what he reasonably believed, and if he had not acted in accordance with the king's wishes, would he have been killed? The second prong of the test was if the answer was yes to the first question of the test, would a sober person of reasonable firmness sharing Graham's characteristics have not responded to whatever he reasonably believed his co-defendant said by participating in the act of killing. The fact that Graham's will have crumbled as a result of alcohol and drugs is irrelevant to the test and was not required to consider. Therefore, the appeal was dismissed. Duress by threat. Limits on the defence. The defence of duress is not available for crimes of murder, attempted murder, or for an accessory to murder, as in the leading case of Abbott and the Queen, 1977. In this case, Abbott had taken part in a brutal killing following death threats against himself and his mother. He had held the victim while she was being attacked with a cutlass and then buried her alive. He was convicted of murder and sentenced to death. He appealed the conviction, contending the defence of duress should have been available. It was held that the appeal was dismissed and conviction upheld. The defence of duress is not available for murder to a principal in the first degree. Where the defendant, for crimes of treason, where the defendant voluntarily, with knowledge of its nature, joined a violent criminal gang. And the case of that is Aaron Sharp. And then where the defendant voluntarily joined a terrorist organisation, and the case for that is Aaron Fitzpatrick. And then where the defendant became indebted to drug dealers, and the case of that is Aaron Ali, 1995, which I'll go through the facts of the case. The appellant had become involved in drug dealing and became indebted to his supplier. The supplier ordered him to rob a bank or a building society, otherwise he would kill him. The supplier gave him a gun and told him to commit the robbery the following day. In directing the jury on the defence of duress, the trial judge had said that the final question is this: did he, in obtaining heroin from Mr. X and supplying it to others for gain, after he knew of Mr. X's reputation for violence, voluntarily put himself in a position where he knew that he was likely to be forced by Mr. X to commit a crime? The appellant appealed, contending that the judge should have said forced by Mr. X to commit armed robbery. It was held, and the appeal was dismissed in the case of Ali, that the crux of the matter, as it seems to us, is knowledge in the defendant of either a violent nature to the gang or the enterprise which he has joined, or a violent disposition in the person or persons involved with him in the criminal activity he voluntarily joined. In our judgment, if a defendant voluntarily participates in a criminal offences with a man X whom he knows to be a violent disposition, likely to require him to perform other criminal acts, he cannot rely upon duress if X does so. The next one is where the defendant could reasonably have taken aversive action. And the case of that is the case of R. Hudson and Taylor, 1971. Duress of circumstances. Duress of circumstances differs from duress by threat in that the circumstances dictate the crime rather than a person. It may well be a person that creates the circumstances, but there's no requirement that a person specifies that a crime must be committed. Although there must be a sufficient nexus between the threat and crime, as in the case of Aaron Cole, 1994. which we mentioned earlier when we looked at duress. Defence of mistake. Where the defendant acts under a mistaken belief of circumstances, they may be afforded the defence of mistake. Where defendant acts under such a mistake, the mistake prevents them forming the mens rea of the crime, and thus mistake is not really a defence as such, but relates to the absence of elements of establishing liability. Initially, a defence would be allowed if the mistake was both honest and reasonably held. And the leading case for that is the leading case of Aaron Tolson. In this case, the appellant married in September 1880. In December 1881, her husband went missing. She was told that he had been on a ship that was lost at sea. 6 years later, believing her husband to be dead, she married another. 11 months later, her husband turned up and she was charged with the offence of bigamy. It was held that she was afforded the defence of mistake as it was reasonable in the circumstances to believe that her husband was dead. A mistake as to the law will not generally suffice for the defence of mistake, since ignorance of the law is no excuse. Ignorotia juris non excusat, as in the case of leading case of R and Lee 2000. In this case, the appellant had failed a breath test. He looked at the test result and saw an air bubble which pushed the test over the limit. When the officer tried to arrest him for the drink driving, the appellant punched him. He was convicted of assaulting a police officer with the intent to resist under Section 38 of the Offences Against the Persons Act 1861. He appealed, contending that he had a genuine belief that the arrest was unlawful. It was held that the mistake was one of the law, and therefore there was of no defence. Although a mistake of civil law may be sufficient to find the defence of mistake, leading case of R and Smith, 1974. The next element is the defence of mistake is in relation to public-private defence. Leading case R and Gladstone, Williams, 1984, and the case of Beckford, 1987. In the case of R and Gladstone Williams, 1984, the appellant witnessed a man attack a youth. He rushed to the aid of the youth and hit the attacker. In fact, the youth had just committed a mugging and the attacker had wrestled him to the ground to prevent him escaping. The appellant was convicted of ABH under Section 47 of the Offences Against the Person Act 1861. He appealed that, contending that the trial judge gave a misdirection to the jury in requiring the mistake to be reasonably held mistake. It was held in this case that the appeal was allowed and the appellant's conviction was quashed. Defence of mistake, implications where the mistake is induced by intoxication, and some leading cases here is the R and Fothergram 1989, R and O'Grady 1987, and R and Hatton 2006. So just have a look at these in your own time, please. Illustrate the application of self-defence rule 5.3. So self-defence, public and private defences cover the common law defences of self-defence, prevention of crime under the Criminal Law Act 1967 and the protection of property under the Criminal Damage Act 1971. The basic premise of public and private defences is that it is in some circumstances lawful to use reasonable force in self-defence, prevention of crime, or to damage property for the protection of other property. Therefore, Self-Defence and Prevention of Crime Act to negate an element of actus reus of the offence rather than operating as true defences. Recently, the Criminal Justice and Immigration Act 2008 has clarified some of the legal principles which emerged from case law and put them on statutory footing. Reasonable force. Section 76 of the Criminal Justice and Immigration Act 2008 puts the common law of reasonable force on a statutory footing. It applies where a person is relying on self-defence or Section 3, subsection 1 of the Criminal Law Act 1967. The question of whether force is used is reasonable contains both subjective elements and objective elements. Reasonable force, the subjective element. Section 76(3) of the Criminal Justice and Immigration Act 2008 provides that the question whether the degree of force used by the defendant was reasonable in the circumstances is to be decided by reference to the circumstances as do you believe them to be. Reasonable force, subjective element continued. Section 76, subsection 4 provides further guidance on the application of the question. If D claims to have a particular belief as regards the existence of circumstances, would A, the reasonableness or otherwise of that belief is relevant to the question whether D genuinely held it, but B, if it is determined that D did genuinely hold it, D is entitled to rely on it for the purpose of subsection 3, whether or not it was mistaken, or if it was mistaken, the mistake was a reasonable one to have made, as in the case of R against Gladstone Williams 1984, which we looked at earlier, and the case of Beckford 1987. Reasonable force, objective element. Whilst the question of reasonable force is decided by reference to the circumstance, the defendant believed them to the level of force is decided objectively, as the leading cases are and Owino 1996 and the case of R and Keane 2010. So in the R and Keane case, the appellant had been out drinking for the night in various pubs. In the final pub, he met a man, offered him a lift home, which he accepted. On the journey home, the driver stopped to get petrol. The appellant got into an argument with one of the other passengers, a young woman. The woman was smoking and the defendant had told her not to smoke as it was dangerous to do so. He became rude and aggressive and pushed her to the ground. The driver went to talk to the appellant. The appellant contended that he thought the driver was about to attack him, so he punched him. The driver fell back and struck his head heavily on the concrete ground. He sustained serious head injuries and had no recollection of the night. The trial judge directed the jury that self-defense was not available where the defendant was the aggressor or had successfully and deliberately provoked the victim. Keane was convicted of GBA and he appealed. The appeal was dismissed. Where the defendant was the aggressor or deliberately provokes the victim into punching him, there's no guaranteed right to rely on self-defense. Self-defense may arise in the case of original aggressor, but only where the violence offered by the victim was so out of proportion to what the original aggressor did that in effect the roles were reversed. Excessive force and murder. There have been some calls for a change where self-defense fails in relation to a murder charge due to excessive force. The argument is that in such cases, the jury should have the option of returning a verdict of manslaughter rather than having the all or nothing approach of murder or no criminal liability at all. And the leading case for this is the case of R and Clegg 1995. In this case, the defendant was a soldier serving in Northern Ireland. He was manning a vehicle checkpoint along with 4 other soldiers. Other soldiers were stationed along the road before and after the place where the defendant was stationed. A car approached the first checkpoint and slowed down. It then accelerated at great speed with its headlights on full beam. Another soldier ordered the car to stop, to no avail. All 4 soldiers at the checkpoint opened fire on the car. The defendant fired 3 bullets as the car was approaching and a final bullet as the car was driving away. The final shot proved to be fatal, hitting a passenger who was in the back seat of the car. The car had been stolen and contained young joyriders, not terrorists. The defendant was convicted of murder and appealed the Court of Appeal. His appeal was rejected on the grounds that in firing the last shot, after the danger had passed, he had used excessive force in the circumstances. However, the Court of Appeal made the following observations. There is one obvious and striking difference between Private Clegg and other persons found guilty of murder. The great majority of persons found guilty of the murder, whether they are terrorist or domestic murderers, kill from an evil and wicked motive. But when Private Clegg set out on patrol on the night of 30th of September 1990, he did so to assist in the maintenance of law and order, and we have no doubt that as he commenced the patrol, he had no intention of unlawful killing or wounding anyone. However, he was suddenly faced with a car driving through an army checkpoint, and being armed with a high-velocity rifle to enable him to combat the threat of terrorism, he decided to fire the fourth shot from his rifle in circumstances which cannot be justified, and the firing of the fourth shot was found unlawful. It is right that Private Clegg should be convicted in respect of unlawful killing of Karen Riley, and that he should receive a just punishment for committing the offence, which ended a young life and caused great sorrow to her parents and relatives of the family. But this court considers, and we believe that many other fair-minded citizens would share this view, that the law would be much more fairer if it had been open to the trial judge to have convicted Private Clegg of the lesser crime of manslaughter on the ground that he did not kill Karen Riley from an evil motive, but because his duties as a soldier, having placed him on the Glen arm with a high-velocity rifle, he reacted wrongly to a situation which suddenly confronted him in the course of his duties. So he identified that, you know, his intentions wasn't the fact that he wanted to murder Karen Riley, but the fact that he actually did it in a way of doing his duty at the same time. So we finished today's session, and thank you for your patience, and thank you for attending the session today. The next session is your assignment session, and please refer to Moodle for any additional resources and any sort of references. The references that we've used in today's session is just listed there, so you could use them. And thank you for attending today's session, and thank you for your patience. Thank you.